Hi, my name is Arlene Rosol, and I'm an attorney with the Office of the County Counsel. Within Santa Clara County, there are 3 law offices: the District Attorney's Office and the Public Defender's Office, which both practice criminal law, and then the Office of the County Counsel. We practice civil law, and we represent the different county agencies and departments. I work for the Office of the County Counsel, specifically in the Child Dependency Unit. And we are 15 lawyers who represent the sole client of the Department of Family and Children's Services. It's our job to advocate for the department's position. In child dependency cases, the department is the petitioner, the moving parties, and that means we are the ones who file the petitions that bring the children before the juvenile court. We represent social workers. Social workers are not specifically trained to practice social work in a courtroom. Social workers are trained to do clinical assessments, to help families, to work with families. They need lawyers because the child dependency laws are very complicated, and every decision that a social worker makes must be legally sufficient. We must present evidence to the court to make all the findings and orders necessary for the children who come under the juvenile court jurisdiction. Within my office, there are 15 lawyers, and we are all dedicated to representing the Department of Family and Children's Services. We represent all the social workers within the department, ranging from the emergency response workers who take the CPS calls and do the upfront investigations. We represent the dependency investigating social workers. They're the ones who file the petitions and who do the investigation for the court to sustain the petition. We represent the continuing social workers. They're the ones who manage the case plans for the families. They provide reunification services, family maintenance services, and post-permanency services. We also represent adoption workers. They're involved after children have been freed, and they work with the families to finalize the adoptions. And we also do appellate work for the department. We file the legal briefs necessary whenever parents or people who don't like the decisions appeal the court's orders. We represent the department in those appellate process. We are supported by 7 court assistants who are paralegals and 7 support staff. Our support staff is responsible for sending out all the notices for statutory required hearings. For every child in the dependency system, we are required to have at least 2 statutory hearings per year. And my office sends out the notice for every single child's hearing, for every single for every single child and every single hearing. My office is also responsible for distributing the reports for every single hearing. We distribute the reports to all the judicial officers, all the attorneys, as well as the parents. Within the Office of the County Counsel, the 15 lawyers are not specifically assigned to specific cases. We cover various departments. There are 3.5 court departments that we appear in every single department. An attorney from the Office of the County Counsel is present in every single department for every single case. We are the only attorneys who do participate in every single case, and that is because the department was the one who filed the petitions that brought the children before the court. County Counsel is involved in all aspects of child welfare cases. We do have an attorney available 24 hours a day, 7 days a week for emergency response social workers. CPS calls come into the department, and if social workers have questions about whether they have sufficient evidence to remove a child, they often consult with County Counsel. The Office of County Counsel also reviews every petition that is filed. The investigating social worker conducts an investigation and then consults with County Counsel to make sure they have sufficient facts to put in the petition. The office also reviews every report that goes out. The reports are considered evidence. When the social worker writes the reports, they're including their investigation and their clinical assessments, and County Counsel need to make sure that those are sufficient evidence for the court to make the findings and orders. In about 95% of the cases, the Office of the County Council has the burden of proof. That means we are the ones who present the evidence to the court, and we are the ones who ask the court to make the findings and orders. Social workers need attorneys to make sure that every petition filed is legally sufficient. County Council also makes sure that all court findings and orders have evidence to support them. We also make sure there's sufficient evidence to support the recommendations. County Council must ensure that the social workers comply with all the legal mandates. County Council also provides training to social workers. We provide training to them on how to write legally sufficient petitions. We also provide training for them on how to write legally sufficient court reports. We provide support when they need to know what evidence is needed to remove children. We consult with them when they need to know if they have sufficient evidence to return children to parents. We consult with them if they want to know if they have sufficient evidence to terminate reunification services. We consult with them when they want to know if they have sufficient evidence to terminate parental rights. And we consult with them to determine whether they have sufficient evidence to dismiss a case. So in conclusion, why do social workers need lawyers? Social workers need lawyers because child dependency cases are governed by a very complex set of laws. There are legal requirements that must be met whenever DFCS becomes involved in a family's life. Social workers want to protect children, and they want to protect children from abuse and neglect, and they want to reunify families whenever they remove children from their parents. There are legal standards that must be met when DFCS gets involved. DFCS has the burden to ensure that all legal requirements are met. DFCS cannot become involved in families' lives without sufficient evidence. DFCS cannot remove parents from children without sufficient evidence. And DFCS cannot terminate parental rights without sufficient evidence. The Office of the County Council advocates for the Department of Family and Children's Services position. And the 15 lawyers in the Child Dependency Unit are all committed to doing the practice of child welfare law.
And now it's my turn. My name is Elizabeth Paff, and I am under the nonprofit umbrella of the Dependency Advocacy Center. And in your handouts, there's a little blurb about us. It includes our mission statement and a chart showing who works under this rather large nonprofit umbrella. And under this umbrella, there are 2 complete law firms, one of which is Office of Dependency Counsel. That's where I work. There's also Family Legal Advocates. In each of those law offices, there are 5 attorneys, 1 supervising attorney, and we each have 1 social worker, our own social worker, and we are separate law firms. I can't stress that enough. We don't share files, we don't share information. We are 2 separate law firms. Oh, and we have a support staff that answers our phone and does our filing. Also under this large umbrella, we have 3 conflict attorneys. That's because in dependency, everybody gets a lawyer, both of the parents. A lot of people say, well, why does each parent get an attorney? In some cases, the most convoluted one that I can remember recently involved 5 different parents and I think 6 or 7 kids. So when you have that many different parents in one extended family, everybody gets a lawyer. Because if I start out representing both parents, and this often happens in dependency cases, both parents it's an intact couple at the beginning of the case, and before long, those interests might diverge. And if they do, each of these people now gets to have a lawyer, and I have to step away. So rather than having that conflict arise later, we do it right at the beginning. So under this large umbrella, we have Family Legal Advocates, we have Office of Dependency Counsel, and then we have 4 conflicts attorneys. These are attorneys who represent children and parents that for some reason can't fit into either one of our offices. And then the most important one, not the most important, but certainly very important to us under this large umbrella, is something that for a while was unique to Santa Clara County. We have mentor parents. These are parents, and they're my personal heroes. These are parents who have been through the dependency system. These are parents who have had substance abuse issues. These are parents who have had children removed from their care. These are parents who even have lost parental rights on a child before. These are parents who have been through this whole system. They're also under our umbrella, and they are not only my heroes, they are wonderful tools for me to use when I'm representing a client. It's easy for me to tell a client, I've had plenty of other parents in your position, but I haven't been there myself. And it's really important for parents to have somebody that has been there before, because it's kind of awkward when I sit down with a parent for the first time. Oftentimes they're frightened, they're angry, they're confused. Confused doesn't even begin to describe it. They're mystified by the whole process. And I sit down with them bright and early in the morning. They might be one of 6 or 7 people that I'm going to talk to that morning. File in hand, I sit down, put my papers down, look them in the eye and say, trust me. Oftentimes that's a little difficult to do. With a mentor parent, they're more likely to trust that mentor parent. So that's what is under our umbrella. What we do is represent parents and their interests within the system. We make sure that they understand their case plan, that they're not being, number one, that their children are being taken away on a legal basis. We want to make sure that the department isn't overstepping its bounds, so we're there to protect the parental rights of these people, because the U.S. Supreme Court has found that parenting your children is a fundamental right. That's really, really important. And if we have any lawyers out there, you understand the importance of a fundamental right. And there is a fundamental right to parent children. So we want to make sure that those rights are protected. One of the things that I ask the CASAs to do is understand that this law, this very specialized niche of law called dependency, is unlike any other law that you may have seen. If you've been in court yourself, if you've been in court for a criminal matter, if you've been in court for family law or on a jury, or I don't know, if you've watched Law and Order, boom, boom, flush everything that you think you know about the legal system, because it doesn't apply in dependency. Now, most of you won't be involved ever in a jurisdiction or a disposition hearing. Those are hearings that happen, or a detention hearing. Those are hearings that you'll learn about from a different judge that will explain those hearings. Most of you won't be there for those. But when you're here for the other ones, sitting in the back, you'll learn a little bit about how this works. But one of the things that you'll notice when you walk in the courtroom is that there's no jury box. We all sit at the same table, and that's by statute. This is supposed to be a little bit less adversarial and a little bit more collaborative, because what we're trying to do, the purpose of this law, is to identify a risk to a child. And once that risk has been identified, to provide the services to mitigate that risk. It's not about saying this is the best, we're going to put this child in the best home for it, because frankly, these children, when they're removed from my clients, they want to go home. Almost universally, they want to go home. And for most of us, a home under an overpass on the Guadalupe River would not be an appropriate home. But for these kids, home is where their parents are, and they want to return home to their parents. And I oftentimes will, if I'm out socially, I don't like to tell people that I'm a lawyer, not because I am ashamed of what I do. I'm very proud of what I do, and I enjoy what I do. But invariably, somebody's going to ask for legal advice, or they'll have a short question. And while there's always short questions, the answers are often quite long. So I avoid that conversation. But when I can't, and somebody says, what kind of lawyer are you? I'll try. I'm a darn good one. Let's talk about the weather. But they insist. And if they do, then I tell them that I represent parents whose children have been removed from their care. And oftentimes there's one person that will give me what I call the look. And it's the look that says, ew, how could you possibly represent somebody that has been cruel to a child? Well, in the first place, not all of them have been, under the legal definition, cruel to their children. But the other thing is that these people, I talked a little bit about a fundamental right. These people have rights, and they're people. And I want to make sure that others understand that when my client comes to court, they're not showing up in a Mercedes. if they're lucky, they might show up on a bicycle. And they have problems. Oftentimes it's poverty. Sometimes it's drug abuse. Sometimes it's anger management issues. They have problems, there's no doubt about that, but they're not bad people. So I ask you to understand that dependency, in all its quirkiness as far as the law is concerned, and all of its differences as far as the law is concerned, basically what the law says is that if the court takes a child away, they're supposed to give it back. It boils down to that. This is about reunification. And for those of you that are volunteering your time, I applaud you. I admire you for your desire to volunteer with this qualification. If you cannot wrap your head and your heart around this notion of reunification, then I would recommend that you find somewhere else to volunteer your time, because that's what this is about. These are people, these are families. And even if it's miserable conditions, the children want to go home, and home is where their parents are. Now in Santa Clara County, we're a little different than other counties in California, and certainly a lot different than other jurisdictions in the United States. And I often tell my clients, if you have to be in this system, be grateful that you're here in Santa Clara County, because this is the county that instituted mediation in dependency. That was unheard of before. We had a wonderful judge here, Judge Edwards, and he instituted a drug court program for dependency, not like the criminal drug court. This is geared toward parents who are in dependency. It provides them with a team of support to try to reunify this family. In this county, years ago, there was a parenting class. Now there's a whole menu of parenting classes. Because ask yourself, is it really, can you have one class? Do you parent an infant the same way you parent a teenager? No, of course not. Speaking of teenagers, you want to get a teenager. I always plug teenagers because they're fun, but they're also the ones where you can make a really, really important big difference. I had a teenager that I represented, because I do occasionally represent minors, and I had a teenager that had a CASA who was there for every step of the way for this minor. And this was a kid who had problems as a result of the abuse that she had suffered. And she had some substance abuse issues herself, she had some runaway behaviors, but that CASA was there every step of the way. So I'm really grateful to the CASAs, the ones that do a really good job of it. And this was somebody who didn't judge the parents, didn't judge the minor, was just there to support the minor. The other thing that happens in these cases is that we'll have cases where a child is taken away. And we had one several years ago that involved an infant. And the parents were substance abusers. They did their case plan, they got it together, they came in, and the foster parents were wonderful. I can't imagine opening my heart and my home to take in a baby that I might have to give back. But that's what these people had signed up for. And after a year, these parents had done what they needed to do, and the people came in, the foster parents, and you could tell by looking at these foster parents that this baby in that home was on its way to Stanford or Cal or Harvard or wherever she might want to go. She was going to have a wonderful life with this foster family. But the parents had done what they needed to do, and there was no longer a risk of having that child with these parents. So even though it broke the hearts of the foster parents, the court returned the baby to the birth parents. And I'm happy to say that case has never come back in, not that I'm aware of. But that's how this is supposed to work. I don't think any of us want the state to come in and decide where a child should be brought up, unless it's absolutely necessary. And that's what our representation is about, to make sure that we're focused on protecting the family. So what we do is defend the family, not just the parents, but the family. And that's what our Dependency Advocacy Center is all about.
My name is Carla Cox, and I am an attorney with LACY, which stands for Legal Advocates for Children and Youth. We are a program that is part of the Law Foundation of Silicon Valley. The Law Foundation of Silicon Valley is a nonprofit organization. Currently, Legal Advocates for Children and Youth have the contract to represent all the minors in Santa Clara County that are part of the dependency system. So basically, any child that is removed from the care of their parents because of abuse and neglect, and if they have to have a detention hearing where there is a court hearing that has to happen within, I believe it's 48 hours of being removed from their parents. At the detention hearing, they will be appointed an attorney to represent the minor. So, and one of those attorneys will either be myself or I have 13 other colleagues that also do dependency work, which is within Legal Advocates for Children and Youth. Now, that attorney does not work for the county. We do not work for the parents. We are appointed by the judge, by the court, to represent the interests of the child, of the minor. Now, we will be appointed to a baby as young as 1 day old up until a minor that is 17 years and 364 days. And oftentimes, once a youth is made dependent of the court, because of a new law that is called AB 12, which went into effect on January 1st, 2012, any youth that is still part of the dependency system at the age of 18 will have the option of being part of extended foster care. So what that means is that I also have clients that are 18, 19, and 20 years old if they opted into the extended foster care program. So what happens normally is an attorney from Lacey will be notified of a hearing that is going to be happening the next day, and I will oftentimes contact the minor and find out, one, if they would like to come to the court hearing, and also find out different information about their placement, their visits with their parents, as well as school issues. So once I find out whether they want to come to court, and also if I meet with them before the hearing, that the thing that I have to find out by law is two things. One is, what is their stated interest? Meaning what it is that they are saying that they want. I also, by law, have to tell the court what I believe is in their best interest, which oftentimes can be different. So, for example, I might be appointed to represent a 10-year-old boy who, after meeting him and then finding out all the information in what's called the detention packet, or the information that's provided by the Department of Family and Children's Services, and maybe the allegations in that packet are about physical abuse, whether or not the child has been hit by the mother or the father in the home. And based on that information, I may feel that it's in the child's best interest not to return to the care of their parent at that time. Now, after talking with the 10-year-old boy and asking various questions and asking, what happened in the home, and he may tell me that he wants to return home, and that any bruises or any evidence of physical abuse was because of him injuring himself on the playground. Whatever it is that he's telling me, if his stated interest is that he wants to return home, I cannot, based on all the information that I have, I cannot by law just advocate for him to go home. I have to consider what is in his best interest. So those two are very important things to keep in mind in terms of when an attorney for the minor does have to represent both the stated interest and the best interest of that minor. Additionally, we have what's called confidential attorney-client relationships with all our clients. Now, another thing that I will often tell my clients is about the importance of this relationship in terms of creating that trust and that rapport with the client. And I often say that in order for me to let that minor child know what possibly could happen, it is important for me to know all the information. So we, attorneys at Lacey, we do believe in creating a rapport with our clients, creating a relationship so that minor that the minor knows that they can trust that attorney and what's happening in court, as well as knowing that they have a voice in what's happening. These proceedings, these dependency proceedings, are about the child, so it is important for us to let that child know that they have a voice in what's happening. Not that the judge is necessarily going to do what that minor wants automatically or every time, but it is important for the judge to know what the child wants. Besides myself, we have 13 other attorneys that work at Lacey, as well as 3 support staff. We also have 7 social workers, and these social workers are completely different than the Department of Family and Children's Service social workers. They are basically resources for minors counsel, for attorneys to use if, for example, there's a recommendation from the department that maybe we're not entirely in agreement with, and what oftentimes will happen is we will ask an attorney, or we'll ask a social worker that works for Lacey to basically have a second opinion as to what they think is in the best interest of that child. Also, there are times when maybe we feel that the Lacey social worker could provide added support, added assistance in that particular case. So we will ask I will ask a Lacey social worker to become involved in that case. I think in terms of relationships with CASAs, any CASA will likely have the most contact with a minor's attorney. And one of the things, especially from hearing from my colleagues, that I think we ask of CASAs is that if the CASA is someone that can befriend that child, that can be a supporting adult, that is going to be with that child through thick and thin, oftentimes we'll have children that will change foster homes, they will change social workers, there will be a lot of different people in that child's life. But if that CASA can be that one adult that is with them, no matter where they're living and no matter what's going on in their lives, then that is a very important role. Additionally, with what's called non-minor dependents, and those are the dependent youth that are over the age of 18, I've seen firsthand how CASAs can provide immense resource and support for these non-minor dependents in terms of helping them kind of navigate their way through learning independent living skills and learning how to become a functioning adult. So I do think that, again, I've seen firsthand what a difference a CASA can make in the lives of the different minors, but especially in the non-minor dependents, which are 18 and over youth. I think, let's see, I think I've covered everything. So,
She's being shy. What she's left out, and in the interest of full disclosure, is that Ms. Cox was also a CASA herself. So she is awesome when it comes to representing kids because she understands it both from the lawyer perspective and that of being a CASA. Now, in your packets, you have a copy of the heading is Attorney's Perspective Panel Discussion. And this is a hypothetical set of facts that we're going to talk about from each of our different perspectives so that you can understand how in a real-life case, what would the county council do, what would the parents' attorneys do, and what would the children's attorney do. So turn to that page, if you will, and read along with me. Carlos Ramirez is 13 years old and currently living in a foster home 15 miles from his original home, shared with 3 younger children. He was removed from the home of his mother and boyfriend 1 year ago when neighbors called 911 about a suspected kitchen fire in the Ramirez apartment. Upon their arrival, firefighters and police found Ms. Ramirez strung out on meth on the sofa. She was unable to tell them the whereabouts of her children. It has been 12 months since DFCS removed Carlos and his 4-year-old half-sister from Ms. Ramirez and the boyfriend's care. Carlos wants desperately to go home and be reunited with his half-sister, mother, and her boyfriend. Carlos's biological father will remain incarcerated for the next 4 years, but Ms. Ramirez's boyfriend of 6 years, who is the half-sister's father, sees himself as Carlos's acting father and is still living in the apartment with Mrs. Ramirez. Carlos has had a child advocate championing his needs for the past 6 months, and he has tried to convince her that he is ready to be reunited with his family. For Carlos's safety and progress, his advocate does not agree. In her court report, which she has shared with the social worker, the advocate has recommended that Carlos not return home yet, as Ms. Ramirez is having difficulty complying with her case plan and maintaining her sobriety. How would county council handle this?
So if a social worker came to me and this was his case and he said, he asks, what should I recommend? First, I start by looking at the petition. So we'll pull out the petition that was filed and that was sustained by the court so that we know what did the court find was true. What were the problems that brought these children to the juvenile court's attention? Based on this set of facts, it looks like mother's substance abuse was the primary problem. While there are many issues presented in this facts, in some ways it's much simpler than cases we often see, and that's because it's only addressing one problem at this point, mother's substance abuse. Sometimes we have substance abuse by both parents, we have domestic violence, we have physical abuse, we have mental health issues, and we have sexual abuse issues. Fortunately, for the purpose of this discussion, I'm going to limit the primary problem as being mother's substance abuse. So the social worker involved with this family has to work with the mother, has to work with Carlos, Carlos, the teenage boy, his 4-year-old sister, and then that sister's father, and also Carlos's father, who's incarcerated. So this one social worker works with the whole family. I'd first focus on the mother. After looking at the petition, we'll look at the mother's case plan. This is what the court ordered the mother to do in order for her to successfully reunify. The law requires every social worker to prepare a case plan that is specifically tailored to each family. For the mother, her case plan will likely include parenting services as well as substance abuse services. Standard recommendations for this type of case in our county would be a case plan that includes a parent orientation. It's a program that's just 2 days, and it gives the parents an overview of what it will be like to be in the dependency system. We also would recommend a parenting class. As Ms. Paff indicated earlier, Santa Clara County is fortunate to have a wide variety of different parenting classes. For this family, mother would need a parenting class specifically for parents with substance abuse issues. So that's likely what we would recommend. It doesn't sound like Carlos has any behavioral problems or any challenging issues. If he did, we would probably even include a parenting class for teenagers. If there were issues related to the younger sibling, we might include a parenting class for parenting children ages 0 to 5 years. But that doesn't seem to be necessary in this particular case, since the primary problem is mother's substance abuse. So the standard substance abuse services that we provide are referrals for drug and alcohol assessments. We would ask the parent to comply with the recommendations from that assessment. Usually recommendations include a drug treatment program. If the mother is actively using, it would likely be an inpatient program. If the mother has some sobriety under her belt, it might be an outpatient program. Additionally, we would recommend that the parent participate in 12-step programs. We would recommend that the parent attend 2, maybe 3 meetings a week, because this is often a very important support group for the parents. They go to these 12-step meetings. They're surrounded by other people who have their same substance abuse problems. So it's a tremendous support for parents with substance abuse problems who need support in maintaining their sobriety. Also, the department would recommend drug testing. That's really the only way we know whether a parent is clean and sober. We recommend drug testing a minimum of 1 time per month on a random basis. But what that means is the parent must call the drug testing agency every single day. And when they're told to come in and test and they don't know when that will be, they must go in to test. In addition to that, after they participate in their outpatient or inpatient program, we would recommend an aftercare program as well as a relapse prevention program. So when we know exactly what mother's case plan is, the social worker then will tell me whether they made the referrals for the program and whether they have maintained contact with the service providers. And all social workers do that. It's either the investigating social worker who files the petition, who makes the initial recommendations, and by the time the continuing worker gets the case, hopefully the parent is already participating in services recommended by the investigating worker, and then it's the continuing worker's responsibility to make sure that parents always have referrals for services they need, and it's the continuing worker's responsibility to make sure they contact the service providers. As I stated before, by law, social workers are required to make reasonable efforts to assist families in reunifying. So we have a case plan tailored to this family's needs, we have referrals made, we have social workers monitoring the parent's progress. And so I would ask the social worker for each element on that case plan, what has been the mother's progress? What has been her compliance? We need to know, is the mother participating in her parenting class? Hopefully by the 12-month review, she's completed that class. Sometimes we have parents who get dropped from a parenting class for excessive absences, but then within 12 months they could get referred again and still have time to complete a parenting class. We want to know what's been her progress with addressing her substance abuse. Did she complete the dad's assessment? Did she get referred to a program? Did she complete that program? Is she still in the program? What has been the compliance? Hopefully the mother is complying with the outpatient program, and even by 12 months it's expected that a parent should be done with the drug treatment program. The 12-step compliance is also important. We want to know, has the mother provided proof of that she's attending? Social workers must meet with their clients a minimum of 1 time a month. And every time they do meet with the clients, the parent is responsible for telling the social worker, here's what I've been doing, working toward my case plan in the last month. That would include bringing her meeting slips. It would include bringing TSRs, which are treatment status reports from their outpatient or inpatient program. I'd ask the social worker, what's been the mom's compliance or what's been the parent's compliance with drug testing? Social workers can pull up a log that shows if the parent called every single day. It will show if the parent tested when they were required to, and it will show what was the result of that test. So we will know whether the mother's calling every day, whether she's testing when she's required to test, whether she's testing clean, or whether she's providing dilute samples or even dirty samples. So there are 3 possibilities that the social worker could recommend here. And it's all going to be based on what's the mother's progress. One option is to return the children to the mother at the 12-month review. And again, as we all agree, that really is the goal of everyone in the courtroom. That's the goal of the child welfare laws. Family reunification is everyone's primary goal. If the mother has excelled or has shown substantial progress in every element of her case plan, maybe she's completed most of it but hasn't completed everything, the social worker could still recommend return to the mother as long as it was safe to do so. And in this particular case, that would mean that the social worker has no concerns that mother has not addressed her substance abuse. That means the social worker believes that mother can safely parent the children at this time. And if that is the case, we would return the children. We do not get out of the case. We're still involved. And instead of reunification services, it now becomes family maintenance services. And the department usually monitors families for 12 months. We can monitor them longer, but usually within 12 months of monitoring children with their parents, parents are ready and the children are ready to get out of the system. And after we reunify the children with the parents, that's our next goal, is to get this family out of the system, knowing that they can be, knowing that the children can be safe and that the parents can protect these children and parent them safely. If that is not the recommendation, if the social worker feels that the mother has made progress, but the social worker is still concerned that it's not safe for the children to go home, then we look at a recommendation to continue reunification services. In most cases, for children over the age of 3 at the time of removal, there is an option to go to 18 months. So we could potentially recommend an additional 6 months of services. And social workers do that if they believe that the parent is close to reunifying but just needs a little bit more time. Maybe the mother's had a relapse at about 3 months into the 3 months into the case plan. Maybe she got dropped from her substance abuse and had to start it over. And so the social worker is thinking that mom needs more time. We can recommend continued services for up to 18 months, as long as the social worker believes that with that additional services, the mother will be able to reunify. In rare cases, we can go to 24 months, but the facts in this particular scenario do not support going that far. And then the third option the social worker has is to terminate reunification services. And in my experience, most social workers do not like making this recommendation, especially after working with the family for 12 months with the goal of reunifying both children with both parents. This is a difficult decision for social workers to make. If the assessment is that the mother is testing dirty, she completed her parenting class, she started her substance abuse class but then was dropped, say she hasn't even been visiting the children consistently, there would not be a likelihood of returning these children even if the mother had 6 more months. There's too much work still to be done in order for mother to maintain her sobriety and show that she can safely parent. So if that is the case, then the department would recommend termination of services, because at this point we need to start focusing on permanency for the children. The goal is no longer to reunify with the mother. So after we recommend termination of services, what happens is that we go on to looking at permanency for these children. We usually set a 366.26 hearing to determine what will be the appropriate permanent plan. For the sister who's 4 years old, she's young, and there is a preference in the law for adoption. Social worker would likely assess her to be adoptable, and then we would want that to be the permanent goal for her. For Carlos, who's 13, he has a right to say whether he wants to be adopted or not. And given Carlos's express desire to be reunified with his parent, the social worker would not likely recommend adoption for Carlos. It may even be, if there's no person to be the legal guardian for Carlos, it may be that we just recommend a permanent plan of long-term foster care. And the good thing about doing that for Carlos is that there still may be a chance down the road where the mother could make some progress, file a 388 petition, and maybe even reunify with Carlos. With the social worker knowing that Carlos wants to return to mother, that would likely be what happens in this case. With respect to mother's boyfriend, it's not clear that he has any issues. Maybe his only problem was he couldn't protect the children from the mother's substance abuse. Hopefully by the 12-month review, he would have completed his parent orientation, and maybe he had to participate in a codependency program. Once he proves that he can safely parent, we would likely return his daughter to him. With respect to Carlos, he could be a potential non-relative extended family member placement. He could also be a de facto parent. It would be in Carlos' best interest, if he couldn't be reunified with his mother, to be with his sister and his sister's father. With respect to the father who's in prison, given the length of his sentence, it's likely that at the very beginning of the case at disposition, we would not have offered him services because there would be no possibility of his reunifying with Carlos within 12 to 18 months, given the length of his sentence. So that's how I would work with the social worker with this particular case.
And now it's my turn. I have to tell you, when I first saw this, if I had seen this when I was taking the bar exam, I would have just quietly packed up my pencils and my belongings and walked out of the room, because this is such a rich fact pattern. There's so much going on here. And from a parent's attorney's perspective, oh my gosh, the possibilities are endless. I could be representing the mother. I could be representing the boyfriend. I could be representing the dad who's in jail. There's any number of people here. Let's start off as if I were representing the mom in this. One of the things that happens, and it's distressing because we see it happen an awful lot, and we still haven't managed to figure out why or how to prevent it. But one of the things that happens with parents when they get close to reunifying, substance abusing parents, when they get close to reunifying, they slip. And it's almost like they're self-destructing. And I don't know if it's the stress of, oh my gosh, I'm almost there. I'm going to have the child back with me. I hope I don't screw it up. We don't know why this happens, but it happens with an alarming regularity. And I'm going to talk to my client here and say, what is it where there's an indication that you're having difficulty complying with your case plan. Tell me about those difficulties. And that's the conversation I'm going to have with my client. And if this is something where, as Ms. Razul said, if this is something where she hasn't done any of the services, she hasn't been visiting the child, she's still actively using drugs, she's not testing, and when she does test, she's testing dirty. If she's completely off the cliff, I can guarantee that she's one of my clients that will want a trial to contest the termination of her services. I won't be successful, but I have a duty to represent her position. I might have a conversation with her that says, to let her know that there's not a lot of hope here with this case, but let's get started on doing that testing right now today and see if we can pull this out of the fire. But I do have a duty to my client to always represent their position. And if it's something outlandish, I can have a conversation with them about, I'm holding up a mirror here, and this is what everybody else is going to think if I make this argument. I'm just letting you know that. I will go in, and then I will go in and make the argument. Whatever my client's position is, that I have a duty to represent that position in the courtroom. We also, one of the things that Ms. Cox brought up, and I just want to digress here for a moment, she brought up this matter of privilege. And within our office, we have, as I indicated, a social worker, and we have these mentor parents. The attorney-client privilege that I have with my client, which means that whatever the client tells me remains a secret. I'm not going to share it. If I have a client that comes in and we're interviewing before the hearing, and if the client says, I got to tell you, I'm high right now. Okay, I can deal with that. Thank you for telling me. Thank you for being honest. I'm not going to tell anybody. You have a right to appear in court, and you have a right not to appear in court. What do you want to do? And they're oftentimes going to say, can you go in for me? And I'm going to go home. Okay, but go to a meeting first. That's one of the conversations that I have. So just to explain that privilege does extend to our mentor parents and to our social workers. Makes the social workers really uncomfortable because they have been trained as mandated reporters. And if they see suspected, or if they suspect abuse of any kind, they are required to report it. Not in this instance. If they're dealing with our clients, they are no longer a mandated reporter as to our clients and our clients' children. The other thing that I want to point out, one of the things that we were supposed to talk about was our relationship with CASAs and what contact we would have with them. What I want CASAs to understand is that my clients sometimes work well with CASAs, sometimes not so much. And here's what I want you to remember. Our clients love their children. They love their families. They love being a part of their family. And oftentimes they're very distressed that their family has been separated. And the fact that a CASA is going to be able to spend more time with their child than they are can be a little bit distressing, and they might be just a tad resentful of a CASA who gets to spend a lot of unsupervised time with their children out doing fun things, while my clients have to visit for 2 hours in a small room at the department with somebody listening to every word. You can appreciate there's a little difference here in the contact that you're having with their clients. And I'm just asking you to understand that they might resent a little bit that you get to have a better relationship with their children than they do in the moment. Now, in this particular case with this mom, I'm going to ask her what happened. And if she tells me, oh, I relapsed. Okay, when did it happen? Last week. How long did it last? She said, it was a one-off thing. I did it. I regretted it. Okay, what did you do next? I called my sponsor. Okay, good answer. What did you do next? I went to a meeting. What did you do next? I went to another meeting. Good so far. What'd you do next? I called my mentor parent. Okay, what'd you do next? It was really hard, but I called the social worker. And anybody who's familiar with the 12-step program or recovery from substance abuse knows that one of the major things that a person has to do is own it. And what this client is telling me is that she has owned it. She has taken all of the right steps so that if the social worker comes in and says that she wants to terminate my client's services, I'm going to say, let's see if we can step back from that and not terminate services. This was not something my client has been a superstar for, well, maybe not for 12 months, because it's possible at that 6-month review hearing. When I'm looking at this, I'm wondering, why are we at 12 months and neither child has been returned? Because the law doesn't say that a child has to be removed for 12 full months. When the risk is mitigated, the child can go home. When there's no current risk to the child, they should be able to go home under the court's and the department's supervision. So I'm a little suspect when I read this that perhaps mom didn't jump into her case plan with both feet immediately. It might have taken her some time, and that's why we're now at 12 months. Now, if I represent the boyfriend, it's another interesting bit of representation. He's the father of this 4-year-old. I don't like being a homewrecker, but sometimes I have to have a conversation with a client that's really, really uncomfortable. And if I'm representing the boyfriend in this case, let's say that the mom, that Mrs. Ramirez in this case, has indeed gone off the cliff. Or let's say that she has not engaged in any of her services. She hasn't been doing what she needs to do to get her children back. But let's say that my client, the boyfriend, has. At some point, I'm going to have a conversation with him that goes something like this. Dude, if you want to get your child back, you have to choose. Who's going to be more important to you, your child or Mrs. Ramirez? Because at this point, you cannot have both. You have to choose one. No judgment here. If you want to choose Mrs. Ramirez, that's fine. We will just waive any further services, and your adorable little girl is probably going to end up adopted. But that's your choice. If he says, no, I want my child, then fine. Usually what they'll say is, well, I want both. No, you're not listening. You can't have both. You can have one. Which do you want? And they invariably will choose their daughter. If he makes that choice, then my next bit of advice to him is, you need to separate from her. You can no longer live in the same home. If it's his home, then he needs to make sure that she leaves. If it's not his home, then he has to go find a home that is separate from Mrs. Ramirez, because she is going to interfere with his ability to reunify with his child. Now, if I represent the incarcerated father, and he gets an attorney too, and oftentimes we get the question, who pays for all these lawyers? Well, the county councils are in the county budget. Ms. Cox and I, our agencies are there's a draft county program, and it's managed by the AOC, which is now called the Judicial Council. They've changed their name. It used to be the Administrative Office of the Courts, and they send out offers for proposals, and our management team submitted the proposal, and we got the contract to represent parents in this county. Lacey also got the contract to represent children in this county. So we periodically have to go back and rebid to try to hold on to these contracts with the county. So we are indirectly financed through the state, but we are paid by our individual law firms for what that's worth. So, and again, everybody gets an attorney, even this guy that's in jail for an extended period of time. If I'm representing him, I will have been corresponding with him and letting him know, keeping him advised of what's going on in the case. But I'm also going to ask how he wants me to proceed. And he might have initially said, there's a lot of services that are available while I'm in custody. I want to do those things. Well, okay, but it's not realistic that the child can be returned to your care no matter how well you do your services. But what I can do is protect his rights as a parent. And if the recommendation here, if the mother is doing really well, and we don't think that the services should be terminated, and if that is the recommendation to terminate services, on behalf of the father, I can support the mother's position that she does not believe that her services should be terminated. If they don't get along and he doesn't really care about Carlos, then he might say, I don't care, let's terminate the services. Again, whatever his position is, that's what I will represent to the court. So in representing each of those particular clients, I'm going to, based on what the department recommends, I'm going to have a different response. If they recommend termination of services, then I'm going to ask for, can we mediate this? Let's have a mediation. Now, mediation is something that for a long time was unique to Santa Clara County. Again, thank you, Judge Edwards, for starting it. But with mediation, what we do is all the attorneys go in with a trained therapist. It's a licensed therapist, and the attorneys all go in and we state our positions. Why do we need a mediator, some people ask. Well, if you put all the attorneys in this small room, all we do is fight. So we need somebody there to sort of referee and keep us from interrupting each other and stepping over each other and really trying to come to a conclusion or come to an agreement. So what we do is we each state our position, our client's position, to the mediator so that they know, all right, how far apart is everybody? And I have been in mediations where the recommendation was to bypass the parents for services entirely and it went all the way up to, we think the children should be returned. There's a lot of space in between there. And I think in that case, we ended up with family maintenance. The children were returned to the parents with court and department supervision. But I will ask for mediation on this case. Sometimes, if people are dug in and they're saying, mediation is not going to help, I am not going to change my position, my client is not going to change my petition, this is going to be a waste of the courts and everybody else's time. Okay, Your Honor, then I'd like an early resolution conference. And in that case, it's slightly different than a mediation, because with an early resolution conference, we go in and the judge kind of participates and acts a little bit like the mediator. And we're in the background negotiating with each other to see if we can come up with a change in language or a change in recommendation, something to make everybody be able to go forward without a trial. Because I believe that Ms. Cox and Ms. Rosul will agree. We're lawyers. We're trained to do trials. And for us, it's a lot of hard work, but it can also be entertaining work. But that's what we're trained to do. I can tell you, and I tell my clients, trials are not good for families. They're just not. Especially if you have parents whose interests have diverged, they're going to get up on the stand. The child is allowed to be there, maybe not the 4-year-old, but Carlos gets to be there, and he gets to hear people saying bad things about each other. He gets to hear the social workers say bad things about the parents. It's just not good for anybody. So we try to avoid trials if we can. Now, if the recommendation is to continue services, then we might have a mediation about, okay, really, my client has been testing consistently. Do we really need to continue testing, or something? There might be something in the case plan that we would see if we could work that out. If the recommendation is for the minors to go home, we're in agreement. Okay. The only thing that we might contest is whether or not the case needs to remain open with family maintenance. But I think given this fact pattern, it's fairly safe to say that we would agree to go forward with family maintenance services. We would probably ask for family maintenance services as opposed to continuing just reunification services. I would probably want the child, Carlos, to be able to come home. He's 13 years old. He wants to come home. He's old enough to look after himself to some degree, and I would probably argue that he could be put back in the home with the mother with some sort of a safety plan that to which everybody can agree, and that way he can go home. Maybe not as much for the 4-year-old half-sister, but certainly Carlos should be able to go home. If he can't, then I would start negotiating to see if we couldn't get him placed with the boyfriend, and Ms. Razul can address how that can be done once Ms. Cox has finished presenting her position.
So in this scenario, I would be appointed to represent both Carlos and his little sister, or the half-sister. At this point, it is the 12-month hearing. So I've likely met with Carlos a handful of times. So the detention hearing has already happened, the jurisdiction and disposition hearing has already occurred, and the 6-month hearing has already happened to get to this point. So likely, I've met with Carlos, talked with him, explained the process as we're going along to this point. So, as Ms. Razul stated, in terms of the potential outcomes or what the recommendation of the department or the social worker could be, is they could be recommending at 12 months, at the 12-month hearing, that the recommendation could be to have a continued services for the parents. So. If that's the recommendation, I would let Carlos know that it sounds like your mom needs a little bit more time to work on everything that she's trying to do in terms of her sobriety and just trying to stay clean and be the best parent that she can be, and that we would need to come back in another 6 months to see what she's been able to do within that time frame. So that would be if that was the recommendation of continued reunification services. Another option would be if the department was recommending termination of reunification services and that there be a permanent plan set up for Carlos. Now, termination of reunification services is completely different than terminating parental rights. At a 12-month hearing, if it's terminating the reunification services, all that's terminating is the efforts that are required by law that the department put forth to help the family reunify. That's all that's ending. At this point, it is not about the parental rights of the parents remain intact, even if the reunification services are terminated. So a lot of times I think that terminology gets confused, and it's just important to note that those two things are separate. In terms of Carlos, if there is a permanent plan that is requested, then adoption, legal guardianship, and just long-term foster care are the choices. Since he's 13, long-term foster care means at least 5 more years in the system, and then at 18 he would basically decide if he wants to remain in extended foster care. During that time, he could have maybe a legal guardianship appointed or a legal guardian appointed if there is someone, and that could be the boyfriend or ex-boyfriend of the mom. That's a possibility down the road. Adoption, because of the bond between Carlos and his mother, I doubt that Carlos would agree to be adopted, and children 12 years of age and older must agree to an adoption. I think at this, it's important to note that in terms of the timeline for reunification services or for just dependency court, the timeline is the children are removed and there is a case plan where the parents are asked to attend classes, parenting classes, attend counseling, also do testing. All of these things that are part of the case plan are there to address the problem that is happening in the family. And the goal is that the child is removed, the parents address the problem and basically, fix the problem so that Carlos would be able to return to the care of his parent, his mother, and be safe. Now, we're not looking for perfect parents. What it is a question of safety. Whether Carlos could be returned to the care of his mother and be safe, not be harmed, not be neglected, be safe. So when we think about that, we want to make sure that we're also keeping in mind that Carlos being in a foster home right now is a great thing, but if he's basically voicing the opinion that he wants to go home, at 13 years old, there is a chance that if he's being told, he cannot go home, and regardless of if people around him and his support team are telling him, that he can still have a relationship with his mother and he can still have, he'll continue to have visits, he may take it upon himself to run away and maybe just go back to his home, whether we like it or not. So I think in this scenario, I would definitely ask a social worker that works for Lacey to maybe assess the situation and talk to Carlos, and with the permission of the parent's attorney, I would ask that I be able to have my social worker speak to the parent to really be able to assess what are the risks to safety, because that is the question that we are trying to ask. So again, what we're looking for, another thing that we want to think about is the idea of permanency, that the reason that we have these timelines in dependency is because a child should not have to basically be in this constant limbo of am I returning home? Am I not? Where am I going to live? And the reason we have these, kind of the 12-month mark is usually a time when we want to say, what is the plan, is because the child should not have to just be in this constant state of limbo. And permanency, whether that's adoption, legal guardianship, or whether that's long-term foster care, at least lets that child know what the plan is going to be. Fortunately, there is still that possibility, even for the parent, if reunification services are ended for this mother since Carlos is 13, there could be a possibility that parent on her own works on her sobriety issues, and maybe down the line, like as long as she keeps in contact with Carlos, maybe 6 months or a year from now on her own, she is able to show the court that she is in a position to be a safe parent for Carlos. And at that point, she can still ask for either 6 more months of reunification services out of permanency, in which we would see if it would be possible for Carlos to return at that point. And maybe Carlos would be older, would be more self-sufficient, and safety would be less of an issue. So that's basically how I would address this scenario. I would also probably agree with a request for mediation, just to see how much of an agreement we can get to. There's also the idea that when a child who's older returns to the care of their family under a plan of family maintenance, there's also services like wraparound services, which are services that are brought into the home by the department, and where there's service providers that are around, which increases the the safety of the child in being back in that home, because there's professionals around that could help in terms of a crisis, or basically being more eyes on the family to make sure that safety is preserved while that child is back in the home. So that's how I would take on this scenario.
I just wanted to follow up on a couple of things. First of all, I shook my head when Ms. Cox said that she would ask if I would give my permission for her social worker to talk to my client. Generally, what we do is I have my social worker coordinate with the Lacey social worker, and they both go. And that way there's somebody from my office that's there to make sure that any conversation that the Lacey representative has with my client does not go beyond the proper boundaries. You also talked about the possibility that Carlos would run away. Ms. Cox and I appear in the courtroom, which is another great thing about San Carlos, or about Santa Clara County, is that we have courtrooms that are separated by age, and we have one courtroom that is absolutely dedicated to teenagers. This judge has a caseload, and probably 95% of her caseload is teenagers, and we both work in that courtroom. It's an interesting population because a lot of times the minors in that case, or in that courtroom, have work to do. It's not just the parents. Maybe the minor is causing problems at home and putting smaller children at risk, and that's why he's been removed. We don't know. But one of the things that we talk about in there is that if a child is, if we believe the child is going to run away, we call that voting with his feet. There was one thing that Ms. Razul, you mentioned that it's possible that since the little girl is 4 years old, she'd be adoptable. And I wrote here, not so fast on the adoption, because she has a father who's still in the picture, and we don't know that the boyfriend has done anything that would justify removing or ultimately, terminating his services and moving toward adoption. And the thing about adoption or terminating parental rights is that you can't terminate parental rights of just one parent. So it's either both parents have their parental rights terminated or neither parent does. You can't have just one parent. There is an exception to the only one parent having parental rights, and that is if a child has been freed for adoption and is not adopted within 3 years, that child can petition the court, not the parents, but the child can petition the court to reinstate the parental rights of either one of his parents. And I actually have 3 different mothers who have had their parental rights reinstated after the devastation of having parental rights terminated. So it does happen. Are there any other questions you can think of that people ask us at this point?
I think oftentimes we'll be asked the question about what role or what we would like to see from CASAs in interacting with the clients. And I just wanted to mention, just because I do have a lot of the older minors, that it is, being a CASA, I believe they still require at least an 18-month commitment to be a CASA. And I think that's important because when you're dealing with children who are in the dependency system, there is a lot of trauma that the children have already been exposed to. There are a lot of issues of abandonment. Sometimes so far in their lives, they have not had good contact or good relationships with adults. So when you are coming into their lives, it's going to be natural for there to be trust issues. It's not going to be something that a child who is part of the dependency system is going to maybe be easily inclined to start trusting someone who is essentially a stranger to them. So I would ask that you keep that in mind, and it's going to take a while to build that relationship. And I think the worst thing that could happen for a child that I'm working with is that they build a relationship with that CASA, and for whatever reason that CASA cannot continue. So after meeting with that person, a couple times and maybe having a relationship for a couple months, if that CASA cannot continue with that child, it's another failed relationship or another adult that has basically let them down. So I just ask that you keep that in mind, because it does affect the child in the sense that I've had clients that will say to me, I used to have a CASA and then they stopped showing up and I'm not sure what happened, I don't know what went wrong, and almost as if they're saying, was it their fault that this person stopped coming around? So I do just want to put that out there. And another thing I like to mention is that you don't have to be, as a CASA, you don't have to be someone that is basically wagging their finger at them, telling them, they should have gotten better grades last semester. You don't have to be that person. You can just be their friend. Be someone that they can count on. Be someone that they can call if they just have questions, if they're sad, if they just want someone that is there to listen. And that in itself is an amazing resource, an amazing relationship that you can have with that child. So just wanted to put that out there as well.
And from the social worker's perspective, the social workers see CASAs as additional support people for these children. Most social workers have 15, 20, even more kids, 15, 20 or more than 20 kids on their caseload, and they can't always have the kind of connection and as much frequent contact with these kids as they'd like to, just because there's not enough hours in a day for them to do that. So to the extent you can be that additional support person to the child, the social worker appreciates that, because although they would like to spend more time with each individual child, it's just not possible for them to do so with their caseloads.
And finally, on behalf of the parents, I think it's important to remember that when a parent is involved in dependency and when a parent is doing a case plan, that the law does not require perfection. The law requires progress and safety. We're not talking about perfection. So please don't expect that of my clients, because let's face it, perfection is the enemy of excellence. If they're doing a good job and the child's going to be safe, congratulate them. And just, if you haven't met the mentors yet, you will, or you'll hear from the mentors. And just remember that the parents are people too, and the children want to go home. And for them, home is where their parents are. So I would just ask you to keep an open mind. I congratulate you and I admire you for volunteering your time and your efforts, and I thank you for doing that.